On April 8, 2020, the UK filed its application to join the Lugano Convention with the Swiss Federal Council, the depositary of the convention. Accession to the Lugano Convention as a replacement for the Brussels I regulation, which was cancelled with Brexit, had emerged as the UK's preferred strategy for judicial cooperation in civil and commercial matters. With the withdrawal of the United Kingdom from the EU, all community law foundations for judicial cooperation in relation to the EU member states are no longer applicable. We are dealing with a hard Brexit in this area. This applies to regulations, for example, on service and the taking of evidence, as well as the core, the mutual recognition and enforcement of judgments according to the European laws. For this area, the Convention on Jurisdiction and the Recognition and Enforcement of Judgments in Civil and Commercial Matters of 2007, the so-called Lugano Convention, would provide an alternative that largely corresponds in scope to the Brussels I regulation. Parties to the Lugano Agreement are the EU, Denmark, due to its special status in matters of judicial cooperation, Norway, Iceland, and Switzerland. The United Kingdom was included in the scope of the convention by virtue of membership in the EU and would now like to join it in its own name. The accession of the United Kingdom requires the unanimous approval of Denmark, Iceland, Norway, Switzerland, and the European Union. Occasionally, it was read that there was a one-year period within which the consent of the other contracting parties had to be given. This is not entirely true, as Article 72 of the Lugano Convention only states that the contracting parties are to give their consent at the latest within 1 year after the request by the depositary. Nevertheless, it is a good idea to take the anniversary as an opportunity to see how far the parties have come. Iceland, Norway, and Switzerland have expressed their support for the accession of Great Britain. The EU, on the other hand, has not yet officially made a decision on this issue. As of today, timely EU approval is highly unlikely, even if the Commission does not position itself clearly in public. The German federal government remained just as vague in its response on January 26th to a written request from Manuela Rottmann, chairwoman of Bündnis 90 Die Grünen in the Bundestag's Legal Committee. And in its response, the Federal Ministry of Justice stated, "The United Kingdom's accession to the Lugano Convention on Jurisdiction and the recognition and enforcement of judgments in civil and commercial matters of October 30th, 2007, could compensate for the abolition of the Brussels 1A regulation. In terms of content, the LUG-Ü, which is called, largely corresponds to the Brussels 1A regulation." On April 8, 2020, the United Kingdom submitted an application to join the LUG-Ü as an independent contracting party. Accession of the United Kingdom requires the consent of all other contracting parties. However, the federal government did not comment on the content. A decision by the EU is still pending. The position to be taken by Germany in this regard will have to be agreed within the federal government. The Financial Times reported on March 12th, citing sources in EU diplomacy, that the UK's refusal to agree to join was seen as part of the EU's broader response to provocative UK post-Brexit response. I mean, the approval of the EU for the UK to join. All of this makes it unlikely that the United Kingdom will join the Lugano Convention in the near future, because that behavior doesn't really stop. And as if things weren't already difficult enough for parties in legal relations with the UK, Rodrigo Rodriguez reports on the EAPIL blog that the Zurich District Court on February 22nd, the application of the Lugano Convention to a judgment of the High Court in London of September 2020, that is, to a judgment that came at a time when the Lugano Convention was still applicable due to the withdrawal agreement. Rodrigo Rodriguez considers the Zurich judgment to be wrong. His analysis is convincing, but as Gerhard van Kalster puts it, whether correct in the specific case or not, The judgment definitely shows that judicial cooperation for British judgments on the continent will be bumpy after the hard Brexit. And it is a complicated thing. And 1 year ago, I made a video about the Lugano Convention, not a complete year ago, but after the application of the UK. And I already talked about that it is problematic because they need the consent of everyone involved. It has to be unanimous. It sounds to me very familiar about the unanimous vote and the veto. And really, with the behavior of the UK government of that time towards especially laws, international laws, they helped come into life, or had to come to life. Would you agree to that? Seriously. I wouldn't. But we will see how this will end up. And if you want to stay informed, please subscribe to my channel. Auf Wiedersehen.